45 attempts. 45 attempts were made to try to reason with Herman Whitfield III, just to get him to cover himself and get into the ambulance. Officers Adam Ahmad and Stephen Sanchez went into the Whitfield home that day with one goal and one goal only, and that was to help Herman Whitfield III, to help him get covered up, get into the ambulance, get to the hospital to receive psychiatric treatment and evaluation. Their actions were objectively reasonable. They had legal authority to do the things that they did. Nothing they did was rude, angry, or insolent. Nothing they did caused Herman Whitfield III to die. And I want to make one thing clear. Herman Whitfield III passing away is an absolute tragedy. I don't envy his parents. I feel terrible for them. And any argument that I make about what happened on this evening, I don't want to take away from that. But the facts are important because their liberty is at stake. So I'm going to talk about it some. The officers' actions weren't only objectively reasonable, but according to the state's own use of force expert, a lot of the officers' conduct that night was actually really good. You heard that the reason that the officers came to the home and the way they responded to the home, that was within generally accepted police practices. The way that Officer Ahmad and Officer Clark de-escalated, communicated with Herman Whitfield III, he commended their job on that. That was within generally accepted police practices. Officer Sanchez's use of the taser, within generally accepted police practices based on the state's case in chief. The only difference of opinion we have with him was the absence of rolling over, which we're going to talk about throughout the rest of our argument. But I want you to pay attention to what Officer Ahmad observed as the first officer in tandem with Officer Clark, what he observed when he got to that residence. First of all, it was not the first thing he observed, but I think it's very important. He saw that Herman Whitfield III had a wound to his lip. And again, I in no way want to make this about the father doing anything that I don't think the father ever wanted to ever punch his son, but he did. It wasn't just a slap. He hit his son. You heard from Dr. O'Neill that this was a deep laceration. It was the deepest laceration he had on his entire body. Officer Ahmad saw that. They knew the reason for it because his dad told them that he attacked his mom and he had to protect Herman from his wife. So they had that information. And the other information that he had was what he saw with his own eyes. He saw a 400-pound man. That would be large for an NFL player. Completely naked, profusely sweating, mostly saying nonsensical things, yelling out, walking around, stopping for no apparent reason, at a very high level of activity. And then Officer Ahmad sees him go into that first floor bedroom, sit on the bed, and that is where Officer Ahmad's perspective is unique. No other officer could see him when he was in there. It was just Officer Ahmad. And what was Officer Ahmad doing? He was observing. Herman went into a room with the light turned off. So Officer Ahmad, to continue to observe, he flashed his flashlight on his torso. And when he did that, there was no response from Herman. So he raised the flashlight up closer to his face. A bright police flashlight in a dark room with the light off. Officer Ahmad testified, and you can see in the video, there was no response. whatsoever with a bright light in his face in the dark. He just wasn't there. He was catatonic. And then so what does Officer Ahmad do at that point? Does he run in and handcuff him? Does he yell at him? Does he threaten him? No, he doesn't. He waits patiently. How long does he wait? As long as it took. How long did it take? Well, Herman was up, now he's down, and he's there for 4 minutes. And then, all of a sudden, he's back up again. And he darts out of the room, he runs past his father, he knocks into Officer Ahmad, he runs through the kitchen, he runs by his mom, who shrieks in terror. He goes into the kitchen, knocks a bunch of stuff all over the place, reaches down to try to pick up these heavy pots and pans. Officer Ahmad tells him, "Put that down, stop that." But he doesn't. He continues running into the dining room, and then he charges in the direction of Officer Sanchez, who then deploys his taser. I want to talk about the taser, but I don't want to spend a lot of time on it because I think we need to put that to bed. The state's own case in chief tells you, with their use of force expert, that his use of taser was proper. It was within generally accepted police practices. It was within his training. It was the right thing to do. So, let's move past that. He shouldn't be held criminally liable for something that he had a right to do that he was supposed to do. One prong, not two, connected with Herman. You heard Dr. O'Neill factor the use of the taser as a contributor of his death, of Herman's death. But I'm sorry, he's just wrong on that. He was basing that opinion on the body cam footage where Herman reacts in some way when the taser's deployed. But you also heard from Dr. Kroll, who is not only an expert in taser and an expert in electricity, but I would argue that he probably knows more about how a taser works than anybody in existence. And he told you that I can look at these pulse graphs and I can tell you this didn't make a good connection, and if you felt the sensation, it would have been akin to when you reach for your door handle in the winter and it gives you a static shock. And to say that that is a contributing factor to death, well, my question is, where's the line? If the officer said something to him that was reasonable for him to say to him, and then he gets agitated by that, are we going to list officer talking to the person as a contribution to death? That's ridiculous. And so is the use of the taser in this case. So let's put that to bed. And then I want to talk about what happened after the taser, which was the decision to go hands-on with Herman Whitfield to handcuff him. Because, again, the state's own use of force expert said the decision to cuff him after that was appropriate and was within accepted police practices, generally accepted police practices. He also said that the manner in which they handcuffed him was the same. It was appropriate. The officers did the correct thing. And not only that, they were obligated to handcuff him. This was an immediate detention. Once it's an immediate detention, which it was clear from every single officer from the jump, they have to handcuff him. So the decision to handcuff him was appropriate. It was totally objectively reasonable. They were mandated to do it, and the manner in which was appropriate. It took a little bit longer than the average cuff. Because of his large size, you're going to have to use 2 pairs of cuffs. Because as he was going to the ground, Herman grabbed that tablecloth and swung it like that. It got tangled up in his arm. That was an obstacle the officers had to deal with. Because when they were trying to cuff him, he was resisting and fighting. All of those factors, their use of force expert agrees, made that whole entire cuffing within generally accepted police practices. And I'm going to argue to you right now that makes it extremely objectively reasonable. So, I want to bring that to the next point very quickly, which is, and my co-counsel is going to talk about this a little bit later. Every single medical expert agreed that Herman Whitfield, his heart stopped prior to cuffing. Several of the medical experts said that he was some version of dead before the conclusion of cuffing. If he dies while they're doing what they're supposed to be doing, and he dies for reasons unbeknownst to them, then they cannot be held criminally liable for that. They just can't. They're doing their job exactly how they're supposed to. If he dies while they're doing that, they can't be held criminally liable for that. And I want to talk about this get on his head stuff. Officer Ahmad told him to get on his head for a very obvious and clear reason that you've heard about from these officers. When officers are in the field, they don't have the luxury of saying a lot of words in a chaotic, in a rapidly evolving, in an uncertain situation. They use shorthand. Hey, get on his head, you get on his left arm. They don't have time, they don't have the luxury to say, hey, can you just watch his head, make sure it's safe, make sure it's turned. They don't have time to explain themselves. They all have shorthand that they know what it means. Officer Sanchez told you. That meant to me, officers are going to be focusing their attention on other areas of this person. I'm going to be the one that's going to pay attention to his head. And how does he do that? He places the hand on the back of the neck, and he doesn't apply any pressure. How do we know that? Well, one, he told you. But number two, Dr. O'Neill told you there was no evidence in the autopsy that any downward force was applied to the back of Herman's head. Officers feel, they index. Damon Young told you that. It's a common technique. It's a good technique. You feel because you react to feel faster than you react to what you can see. Officer Sanchez used his right hand while he was feeling the neck to assist in cuffing because Herman was fighting. When he looks over here, if he's responsible for the head, as Officer Ahmad asked him to be, how do you monitor the head when you're looking over here? You feel. To make sure that head's still turned to the side. To make sure that head's not thrashing and hurting hurting himself or anyone else. That's how they do that. It's a very simple technique and it's a good one. And that's all he was doing. And we know that he wasn't putting downward pressure. There is an angle on Adam Ahmad's camera that I pointed out on direct of Officer Sanchez because it could be interpreted, if you didn't know any better, that he's leaning forward. But his hands are like this, one on the back of his neck, and one is over here to the right. And there's a time when he takes his hands up and his chest stays the exact same position. All of his weight was on his knees. He was not applying downward pressure on Herman during cuffing, and especially not after. And I want to talk about, well, and also the injury to the head being caused by Officer Sanchez is, I think, a little bit ridiculous. Herman had crashed through that whole house, knocked stuff all over the place before anybody got there. Herman was hit in the face by his own dad before he even got there. It doesn't even make sense that pushing down on the head would cause an abrasion like that on his head. We don't know how that got there, but it probably got there before the police even arrived. But after cuffing, I want to talk about that. We've already established that if he died during cuffing, and he clearly did, and the cuffing was legitimate, that's game over. They can't be guilty for that. But after cuffing, there was no pressure applied on him after cuffing. They were indexing, they were feeling. There's no evidence of that, period. And the state wants to say, well, we only have to show even a light touching can be battery. Okay. But what I'm here to tell you is nothing that they did while they're indexing is rude, angry, or insolent. What's rude about that? They're not controlling Herman. When they say control, they describe to you. What they mean is, we're feeling. Because if he gets back to that excited state, what's that going to do? First of all, it's going to delay the medics coming in. He can't go to the hospital, which is what everybody agrees he needs to do for his psychiatric issues. He can't go until the medics can come in. If he gets up and fights again, that's going to delay the medics. So they're feeling in the event that he does do that. They're not pushing down and preventing him from moving. That's just not what was happening. And Officer Ahmad's decision not to roll him over, he told you, it was based off the activity that he had already seen. And the other thing is, Officer Clark asked those medics to stage. Okay? You know what that is now. They're outside. Officer Ahmad knew that the medics were staged outside. Officer Sanchez knew. Officer Burt knew. The only officer that said on the stand, doesn't remember if they were staged outside or not, was the rookie, Officer Matthew. He's the only one that suggested anyone roll Herman over, and he's the only one that didn't remember whether or not medics were staged outside. That's why a rookie is a rookie. That's why he was still in training. That's why he still has a field training officer supervising him. Because he missed that detail. If the medics aren't staged outside, that is a different analysis, sure. But they were. And Officer Ahmad knew that, and Officer Sanchez knew that. And they told you. They're right outside. Once they're radioed to come in, I'm thinking they're going to come in seconds. Not 60, but probably 15. And then, once the medics get to the front door, it takes a minute and a half for them to get to the side of Herman. And, you know, in hindsight, we all wanted that. I wanted that to be faster. The officers wanted that to be faster. But what's important is, once paramedic Neasley, once she actually gets to Herman, that's what matters. Because what happens is, she talks to Herman. Hey man, learns his name. Hey, Herman, no response. Okay? She touches Herman. She says, okay, I'll be right back. Hey, officers, if you can get him to roll over, that would be great. And then she walks away. She sees that he's naked. She sees that he's sweaty. She sees that he's unresponsive. She touches him. She talks to him. She has all the same information that these two officers had. The state wants you to believe that they're criminals because they didn't recognize the medical distress, because they didn't roll him over, because they didn't feel for the pulse, because they didn't start CPR. Paramedic Neasley, once she got to that patient, she touched him, she talked to him, she saw him. She had all that same information. And she didn't do that. She didn't check his pulse till later. She didn't yell at the officers, why isn't he rolled over? Roll him over. Come on, let's start CPR. She didn't do any of that. So you want to convict them of a crime for having the same reaction and observations as the paramedic did when she first encountered Herman? That's not a crime.
You have 12 minutes left. You're
30.
Yes.
I have a defendant's exhibit E, which is the 5-camera multi-view of piecing 5 of the officers' body camera footage together. Can you take it down when I find it? And we created this because we wanted you to see them all together, because we think that's important. And what I want to play for you is when Delaney Neasley actually comes to the side of Herman Whitfield. And I'm starting at 7:36. I think it's a little too late for that bird play. not blaming Delaney Neeson. My point is, she was right at him. She had all that information. She didn't do the things the state wants them to be criminals for. I want to talk about, you probably heard more medical testimony than you wanted to, but I want to talk about some of it. First of all, you know this already, I don't want to beat it to death, but homicide as a determination of, on the autopsy as a manner of death, the only value that has is that Herman Whitfield passed away while the officers were in contact with him. Beyond that, you can set it to the side. Dr. O'Neill told you that it is a neutral categorization for statistics, that it has nothing to do with legal culpability whatsoever, the legal definition of homicide whatsoever, and when there is a homicide determination for manner of death, the people involved in that scenario, all that activity could be completely innocent and it could still say homicide. It brings no value to your evaluation beyond the fact that, yeah, they were touching Herman Whitfield when he died because they were properly and legally and reasonably handcuffing him at the time that he died. I want to talk about, Ms. Skelton pointed out that there was only one forensic pathologist who testified in this trial, Dr. O'Neill. And I want to talk about his cause of death. He said that there were 5 components that all came together in a constellation and a congruence that caused his death. But what he also said, and 2 of those were the fact that Herman Whitfield was hypertensive, had an abnormally large heart, and was morbidly obese. Things that were out of the control completely of Officers Ahmad and Sanchez. But what he said was, he could not assign certain percentages to which factor played what role. He could not say that one factor was more important than the other, was more influential in his death than the other. In fact, he said that it's possible that even if Herman was never put in the prone position, that he still would have died. So, the only forensic pathologist that testified said that even if Herman Whitfield was never put in the prone position by officers, that he still could have died. Dr. Smock told you that he was going to die. But if the state wants to rely on the forensic pathologist, that's okay, because he told you that it's a possibility that he would have died even without the prone position. That is reasonable doubt. If you think they're just possibly guilty, that's not guilty beyond a reasonable doubt. That's not guilty. And I want to talk about Dr. Steinberg. And I want to point out a couple red flags with his opinions. His opinion, first of all, on cause of death, in this case, is prone restraint cardiac arrest. And he coined that term. That's his term. And his opinion on that, as it applies to this case and in general, comes from just his own 2 articles that he wrote. And I also want to... He was talking about Dr. O'Neill's cause of death. Pulmonary arrest in the setting of law enforcement subdual. And he said initially, pulmonary arrest from law enforcement subdual. And when he was asked about that, because that's not what the cause of death was, it is in fact in the setting of, he acted like there's no distinction.
5-minute warning.
He came up with the conclusion that he wanted to meet first, and then he fit the evidence to it. And when he was confronted with it, he still acted like it was all the same. Cardiopulmonary arrest from law enforcement subdual means that the law enforcement subdual caused the cardiac arrest. In the setting of just means in the setting of. Those are two different things. And he wants you to think that, well, Dr. Smock and his THC theory, you're crazy if you think that, because people dying from THC, and people having a heart event from THC, that's rare. That's crazy. And then he goes on to say, well, I mean, my theory that I came up with is rare too, but you should believe my theory that's rare over Dr. Smock's theory that's rare, that he's seen multiple times in his own practice of decades in the emergency room, and that is supported by medical literature. And this simply was not positional asphyxia. All the general orders contemplate, you need to roll them over, you need to do this, you need to do that, because of positional asphyxia. Not a single medical expert said this was positional asphyxia. In fact, Dr. Smock, the leading positional asphyxia expert, said this was not positional asphyxia. This is what I study, this is what I do, this is what I see. He was one of the lead medical witnesses in the biggest positional asphyxia case that's ever been in this country. This was not positional asphyxia. So we're arguing about whether or not they were in compliance with general orders to prevent a thing that didn't happen in this case. Herman Whitfield doesn't react well to THC. Is that rare? Probably. But does that apply to him? Yes, it does. In 2020, he went to the emergency room because, and you have these records, he went to the emergency room because he tested positive for THC, and he was acting in many ways differently in this case because he was being deliberately, well, not deliberately, but explicitly they stated he was being aggressive, he was being non-compliant. They had to restrain him in the hospital. And that's because he took THC then, he had an adverse reaction, and he was told that he needed to that he should seek some kind of drug treatment in his discharge papers. We know that for him, for whatever reason, he has an adverse reaction to THC. We just know that. And we also know that his parents, at least, believed that this wasn't normal behavior for him. Well, it's because he took THC. It does something to him. Probably doesn't do it to any of you, but it does it to him. And he didn't just die from THC. The THC is what caused his death, but the THC found Herman as he was, which was somebody who, as Dr. O'Neill told you, just the size of his heart alone put him at an increased risk for sudden cardiac death. This wasn't unique that this was a police-involved case. It was the fact that he was strenuously running around because he was having an issue from THC, and the THC pushed him over the edge and caused his death. I want to talk to you very briefly about the burden the state has in this case, and I'm going to pass it over to my co-counsel. You've been instructed, and you'll be instructed again, that the state's burden is very high. It is a heavy burden. And I just want to point out a few things. If you believe that it's been proven that they're not guilty, that's an easy one. That's not guilty. Moving up, if you think that it's possible he's not guilty, that's not guilty. But then we get into where it's a little less intuitive. Perhaps he's guilty. Maybe he's guilty. That's not guilty. I think he is possibly guilty, not guilty. I think he is probably guilty, not guilty. You get up all the way to guilty is highly likely in your mind. If that's as high as you get, guilty is highly likely, that's still not guilty. The only way he's guilty is if he's guilty beyond all reasonable doubt. And speaking of possibly, I think he is possibly guilty. Well, it's possible that Herman Whitfield died having nothing to do with the prone position. So if that's possible, then at most they could be possibly guilty, which is not guilty. So we're going to ask that you find him not guilty, but I'm going to bring up my co-counsel to complete our argument. Thank you very much.
Day to protect the law, to follow the law, to protect society, and for them to be thrust into a position where they find themselves in the limelight as defendants in a criminal court. And that's why we're here. Don't forget why we're here. The forum is the Marion County Criminal Court. We are not in a civil court of law. We're not at a disciplinary merit board. We're not an IPD policy board or a citizens complaint board. We're not having a policy review from the chief or from the mayor. It's not a community oversight forum. Those may be legitimate questions for another day. But today, the question is, are those guys felons? That's what you got to decide. It's the only thing that you got to decide in this courtroom today. Why are we here? I think we are here because it was a tragic outcome. I think it's about the optics of a terrible situation where someone died associated with police. But we're not here due to criminal conduct, because that's what the facts and the law are about. And that's what the state has woefully failed to prove. As a matter of fact, I think so woefully that the defense has disproved that they committed any crimes. I want to talk about this idea of association versus causation. Association versus causation. The question is, did Mr. Whitfield die associated with police conduct, involvement, interaction, or did he die caused by, causation? That's the question. And where do you get the clue to that question? The clue to that question is in the autopsy report. On the front page, Dr. O'Neill doesn't say they got cardiopulmonary arrest due to the actions of the police. It says in the setting of the police. It's the very first thing I noticed when I got the autopsy report. This case is about an associated death with a police interaction, not by one that was caused by police interaction. And that is why we should not be standing in any court, let alone a criminal court. Now, it might be easy to think of this trial as just trying to decide if the officers made any kind of mistakes or poor judgments or even acted negligently. Negligence is for civil courtrooms. Negligence is the failure to use ordinary care. Civil law, the judge will instruct you, that's not what we're here for. So even if you think mistakes were made and should have been done better, and they failed to use ordinary care, and they were potentially negligent, it's for down the road. Remember when Mr. Whitfield Sr. was on the stand, we talked about the fact that they've already filed a federal civil lawsuit. Those issues will be debated someday, but not in this courtroom. No matter how these charges are analyzed, the state can't come anywhere close to proving criminal conduct. The defense has no burden whatsoever to prove anything, yet I believe that we proved that the state has failed, and we proved that there was no crime committed. And don't let the prosecutor overcomplicate this case. You heard from, as my partner said, ad nauseum from all kinds of medical experts. But the point is, it doesn't take a rocket scientist or a brain surgeon to tell you that a guy with a 500-pound enlarged heart, with hypertensive disease, with microscopic thickening of his walls, and he has all these things going on in addition to the morbid obesity. Dr. O'Neill himself told you at any time he could have fallen over dead, and I can't tell you what percentage played in any relationship to the sudden cardiac death. Could have been 5%, could have been 1%. The prone positioning could have been 0%, could have been 6%. He's got no idea. You heard Smock say that he was a ticking time bomb, and in Smock's opinion, the THC lit the fuse. But you don't have to overcomplicate this. When a guy with that diseased of a heart, with those kinds of issues going on, decides to overexert him, he's 400 pounds. He's bigger than any player in the National Football League. And he's trying to exert himself, trying to avoided getting handcuffed so that they could get him transported for some help to the hospital, and his heart conks out. It doesn't have to be any crazier than that. Don't let them overcomplicate this case. And let's face it, there's only one real allegation here, that the officers failed to roll him. And I'm going to come to that in a minute. They had to put in the legal pleadings that he killed him. They have the burden of proving that he killed him, or they killed him. But the allegation, as you now know it, is they failed to roll him. You heard from their own expert that they flew in from South Carolina. 6 out of the 7 issues he reviewed was very good police work. But he had an issue with the failure to roll. He didn't say an issue with killing him. He had an issue with the failure to roll. That's the civil question, folks, not the criminal question. That's an omission. A failure to roll is an omission to act, not an act. They got to prove a criminal act. It never happened, and it never came close to happening in this courtroom. There's numerous hurdles, other hurdles to overcome. Was Ahmad's rationale for not immediately rolling him a plausible and justifiable decision? Does it really sound that crazy after what he had seen and experienced, that he didn't want the guy to get back up? That he was happy that the guy had returned to this catatonic state that he was in? And he wasn't going to do anything to change that machinery? After all, the medics were coming right in the door. Why would he want to rouse someone and they'd have to even further delay the treatment for the guy because they'd have to reapprehend him? Does that sound like a crazy decision? Something that's a substantial deviation from the norm? Unless the state overcomes that and so many other hurdles, you'll see an instruction that says even a mistaken belief by the police does not make a crime. So even if you think, Ahmed, well, that's what he articulated his response, but I just think he was wrong. That's why the instruction is in the law, that a mistaken belief can't form the basis of criminal intent. If you find that the cause of death was sudden cardiac arrest, which all experts agree to, and that it occurred prior to the completion of cuffing, which all doctors agree to. By definition, the failure to roll didn't kill him because he was already dead. That's the problem they have with this case. Why it's a civil case. They can't prove that the act of failing to roll or omission of failing to roll is a killing agent, what killed him. You would have to find only that that failure somehow killed him, which I said, I don't know how you can find it if he's already dead. But then you'd have to go down the decision tree and say, well, was there a battery? Well, once again, how is a failure to touch somebody a battery? And it certainly isn't rude, insolent, or angry, so you never get to that decision tree. Same with the reckless homicide count. There was no substantial deviation from the norm where there was an unjustifiable disregard by the police officers. At most, once again, policy violation, negligence at most. I don't even think it's there, but it's not a criminal case. The evidence is overwhelming that there was zero, none, nada, inappropriate, excessive force, leverage, pressure, or anything else immediately after the cuffing was done. And under Indiana law, officers are allowed to touch people. That's what the legal authority statute's in there for. Legal authority statute says they were absolutely within their rights to use whatever force they needed to get him cuffed. Once that happens, they didn't do anything to him. They kneeled next to him, they indexed him, and made sure he didn't jump up. They were just happy he had returned to his unresponsive state, and they were saying, well, the medics are on their way in. What's the deal? We got to get him on the cot and get him transported. Is that an unreasonable, crazy thought by the police to analyze what was going on at that time? I don't think so. And the best proof that nobody believed that Whitfield was in a true life-endangering medical distress is that both the officers and the medics made the same decision. My partner pointed out to you, when the EMT paramedic comes in, she kneels down, she evaluates. She doesn't say, I gotta get a pulse. Why haven't you rolled him? What are you guys doing? She tries to talk to the guy like he's gonna respond and walks away for a while. And yet they're the criminals. It's ridiculous. The proof is not there, and it doesn't meet common sense. There was no maximal restraint. There was no improper restraint. There was no difficulty breathing that was seen. There was no signs of medical distress. It never happened. It's all based on this two sides that they saw of Mr. Whitfield. Was he in that catatonic, unresponsive state, or was he about to go manic again? They didn't know, and they couldn't risk how that was going to come down. You heard the rationale of Ahmad, and I won't have to go through that again about him not wanting to go there. It's crystal clear that all the experts agreed that there was no positional asphyxia. And all that stuff about the policy language that you saw about, it's all on the chapter of positional asphyxia. I'm going to show that to you in just a second. It's a red herring. There was no positional asphyxia. Their own expert, Dr. Steinberg, who came in from Beverly Hills, he told you it's not positional asphyxia. And yet we're supposed to believe all that language is supposed to make a difference. As my partner talked about, there's also obviously, through Kroll and everybody else, no taser electrocution because the taser didn't even complete a circuit and no electricity ran through it. Matter of fact, you won't even find a charge in the charges on taser usage because it's a non-issue. Another red herring from the state. And maybe one of the biggest elephants in the room is you aren't really sure what to do with all these experts you heard from. If one thing is crystal clear, even if you believe Steinberg more than Smock, which I don't know how you could. Smock is the preeminent guy in the world on this stuff. But even if you're confused by those experts, throw them all out. decide that they're having a scholarly debate about cause of death. But if the experts can't agree how the death was caused, how are these working stiff cops supposed to have known that their actions were going to kill the guy? Ask yourself that. I want to do a little bit about explaining some of the exhibits to you, just so you can recall what they were. And I'll go very quickly. Judge, how am I doing on time?
You have 15 minutes.
Thank you. You saw the evidence from the 911 call. Well, here's the transcript from it. Remember, Mrs. Whitfield says, no, he doesn't do drugs, and he's never been diagnosed with anything. We know those two assertions are flat out wrong. They knew about the admission in Florida. They know about the records that you're going to see. I don't know why they weren't being honest about it. Maybe in the long run they're trying to preserve their civil suit. Maybe they were so distressed she's not thinking of it. I don't have any idea. But we know that he had severe psychotic issues, which Dr. Smock talked about how that's a precursor to exactly what happened. And we know that he was a THC user and that that can be the fuse to light the ticking time bomb. It was the defense that went through with you the timeline with no burden once again. And we showed you the elapsed times between all these incidents. And we showed you the amount of time that passed. Number one, as my partner talked about, the unbelievable effort to try to use de-escalation techniques to get him to voluntarily comply. But when he decided to change the action and he needed to be handcuffed so he could be transported, then at that point you start looking at the elapsed time and you see the actions of the paramedics. And the paramedics are coming in and they're not saying, where's the pulse? Why haven't you rolled him over? What's the deal here? You guys are callous. You're indifferent. They would have taken charge if they thought something was wrong. Measley wouldn't be talking to someone she thought was dead or in medical distress. She wouldn't be trying to reason with, hey, Herman. Why would they think it if the professional didn't think it? You remember this that I put up with Mr. Adams from South Carolina. 6 of the 7 issues he reviewed were good police work, very good police work, he said. And he just had a question as to whether or not it was improper, their quote, failure to roll. Once again, not kill him, the failure to roll. You have the evidence of the EMT, and here's what I thought was significant about that really didn't come up a lot in the trial. But first of all, you see that the chief complaint and primary impression was cardiac arrest. There's no doubt that he died of this sudden cardiac arrest. But look in there where it says mechanism of injury about halfway down. There's nothing there. You don't have any notation there from the EMT that there was any failure by the police that mechanized the injury, mechanized the death. Nothing whatsoever is put down by the EMT. You have the toxicology results, which we know were a 12.1 number. Depending on your cutoff value, Dr. Smock said that that's 6 times higher than other cases he's reviewed that caused THC-induced sudden cardiac arrest that can occur at a level of 2. This was 12, 6 times higher than that by the blood draw at the autopsy. Here was the form that you saw throughout the case about the positional asphyxia and all the things that the prosecutor wanted to go through. The problem is this thing about positional asphyxia and all those rules the prosecutor wants to put up, it's a complete red herring because their own expert says there was no positional asphyxia. That's not how he died. I would submit to you this is all subterfuge. It's all red herring. It has nothing to do with the case. Even if you thought it had to do with the case, you turn to the rule that really matters, and that's the one that says the rolling him over only occurs when it's safe, appropriate, and feasible. Was it a rational decision for Ahmad to say, in my mind, it's not safe, appropriate, and feasible to roll him yet because I think he's just unresponsive and I'm not going to relight him into this manic state. That's the definition of deciding if something is safe and feasible and reasonable, right? And that's what he did, and that's why it's a legitimate response. And once again, if you find that that doesn't make sense to you, he's mistaken. A mistaken belief does not form a criminal conviction case. That's what the instructions are there for you for. I was so struck by all these experts we had, and Dr. O'Neill tried to do the best job he did with the forensic examination. But I actually wanted to make sure I was hearing stuff right that he was saying. And I had the court reporter type up for me the transcript of his testimony. And I want to remind you of a few things that Dr. O'Neill said. Do you recall the stuff about genetic testing and Smock talking about channelopathies and genetic testing and how that could show the precursor of this sudden death occurring? Do you recall him saying that, yeah, that stuff can show that a bad episode could happen? He says that testing can show things that lead from fainting or syncope all the way up to sudden cardiac death, right? We asked him, well, why did you do that? Well, we have to be careful of what we're ordering and to make sure we don't overspend on things that aren't useful. After a person dies, you no longer have health insurance. That would either come through the coroner's office or taxpayer dollars. That could be exorbitant. They're going to put these guys on trial for their liberty because they didn't want to spend the extra $1,000 to get genetic testing that would have solved this puzzle? He talks about the heart weighed 510 pounds. And he said, something that wrong with the heart at any moment, heart could result in death. He says the guy, through the enlarged heart, underlying blood pressure, and morbid obesity, he could, quote, have heart issues at any moment. He says, when he was asked the question, is it hard for you to say that rolling Herman over sooner could have resulted in a different outcome? Yes, you're certainly right. If someone's in asystole, it's not like CPR is going to save him. Is that right? Yes, you are correct. Is it possible that had he not been placed in the prone position, he would have died anyway? Yes, it is possible. And there's just no way for you to tell which one factor, if removed, would have caused him to have died. I would agree with that. There's the guy that did the forensic examination, and he can't establish how the death occurred. I want to work through with you a little bit of a blueprint analysis of what happened, but I don't want to make it any more difficult than it needs to be. First of all, counts 3, 4, and 5 are just window dressing. Those are the counts that talk about him being injured. We're not here for an injury case, we're here for a death case. Those are all not guilty. The question is counts 1 and 2. Was there a manslaughter by commission of a battery, and was there a reckless homicide? But if you look at the salient feature of both of those counts, they both require that the cops killed Whitfield. So you have to ask yourself, did the state prove action that caused proximate death? Did the state prove that the police actions killed him? And were those actions criminal? I would find that it was not guilty, because even if you go on down that decision tree, is the failure to roll rude, insolent, or angry? Did they have a high probability that it was going to cause death? Or was it merely negligent or mistaken? And same on the reckless homicide. Was it a conscious and unjustifiable disregard by them, or a substantial deviation of acceptable standards? Or was their decision at most merely mistaken or negligent? That's why I think, number one, quickly through the question on proximate cause of death, you'll never get there. But even if you have to go to those other decision trees, you would work through those issues. I want to touch on the instructions. You will be instructed that the case can't be based on sympathy. It's a tragic outcome, but you have to rule on the facts. You'll be instructed that you decide the law and the facts in this criminal court and whether or not they deserve to be convicted felons. You will be instructed that on legally responsible, a death would not have occurred without the conduct. the death would not have occurred without the contact. You have to decide that. The death didn't occur due to a failure to roll. He was already in cardiac arrest, unbeknownst to everyone. Therefore, that failure cannot be proximate cause. The legal authority statute we've already talked about. The mistaken belief by the police cannot be a basis for a crime.
5 minutes,
versus
counsel.
Connor. I'm sorry?
5 minutes?
Thank you. Graham versus Connor is also in there. You can't judge this case based upon 20/20 hindsight. You must base it on what the officer might have been thinking at the scene, the objective reasonableness of the officer at the scene. That's just a few of the key instructions that you're going to have when you go through that, and then you'll go through the verdict form at the very end of this. A few other things, points that I want to make with you before I run out of time. The prosecutors continue to say that they kept him prone. They didn't keep him prone anywhere. All they did was kneel beside him and make sure he didn't jump back up. And keeping him prone is another way of saying failure to roll, and that's the same allegation. But if he died before the cuffing was completed, the allegation can't then prove that that action was the proximate cause of death. So I wanted to put this up for you toward the end here. Everything is presupposing and dependent on, did the police kill Whitfield? Did their actions kill Whitfield? Well, what do we know from every expert in the trial? Kroll said no, because 15 seconds prior to cuffing, he was dead. Smock, no, 15 to 20 seconds prior to cuffing, he was dead. Steinberg, 7 to 15 seconds prior to cuffing, and O'Neill, 22 seconds prior to cuffing. Folks, you can't illegally kill someone that is already dead while you're still performing an authorized act. They had the right to handcuff him. If he dies during handcuffing, there is no killing that occurred. It dawned on me how we got here. They weren't charged with failure to roll. You won't find that in the language. They weren't charged with failure to resuscitate. And why? Because the prosecutor knows that would be a civil charge. They had to allege killing to get into criminal court. And that's why we shouldn't be here. You're going to have the opportunity to end this nightmare, not only for the Whitfield family, but for these officers. To go back, review the evidence, and come back with a not guilty verdict across the board for these officers. But I want to remind you of one final thing. Because the state has the burden of proof, and only the burden of proof, not only to prove all the cases, but to disprove our defenses, they get the chance to stand up after I sit down and have one more bite at the apple with you. But I can promise you this. Nothing more that they say will undo the facts in this case. It won't undo the points that I've made to you. It won't change the facts. It won't change the law. The evidence is clear. There was no crime. And that's why you are compelled to return a verdict of not guilty. Thank you.
State when you begin, you'll have 13:38 left.
And Judge, will you tell me what I've used, when I have 3 minutes remaining?
3 minutes, yes.
Here's how we know there's a problem. We know there's a problem because the last 60 minutes were about literally anything other than what we are here for, which is what those two defendants did to Herman Whitfield on the floor of his parents' house in April of 2022. We know it's a problem about what they did because everyone else is lying, everyone else is wrong, everyone else is conspiring against them, including Herman's own mother, who on a 911 call was just accused of lying in service of a civil suit that couldn't even exist because all she wanted was for her son to have help. You remember what she asked Officer Clark when she came in? You're not going to kill him, are you? If only they hadn't. But that's exactly what they did. She didn't call 911 wanting her son to die. That's what happened. Everyone is at fault except the officers. And that's how we know there's more going on to this case than what we were able to see on the body cam. They want to blame Delaney Knisley, the medic, who knew everything that the police knew. She knew nothing. The police told her nothing. She had asked twice how long has he been down. She didn't know he'd been blasted with a taser. She didn't know about his condition ahead of time. She knew absolutely nothing other than she walked in and they had him in a dangerous position. There's no way she could have known what was happening. She sprung into action when she realized it was a problem. The defense wants to tell you that they didn't know what they were doing was a problem. It is flashing red and green, or flashing red lights for Herman Whitfield. He's basically the reason that General Order 8.1 was written. If Damon Young was going to train officers adequately about how to respond to someone who's in crisis, you would look at someone like Herman Whitfield and you would say, officers, this man needs your help. You don't put him on his stomach because he's overweight. You don't put him on his stomach because he's in agitation, because he's acting bizarrely, because he's yelling. Because if you put him on his stomach, he could die. It's not a hypothetical. It's not a possibility. It's exactly what happened. Call it positional asphyxia, call it whatever you want. When that man is on his stomach, it was harder for him to breathe. And when it was harder for him to breathe, he couldn't get carbon dioxide out of his lungs. And because he needed 100% of his opportunity to breathe, he died. That is the most simple, straightforward, reasonable explanation for why Herman is no longer with us. Dr. Smock would have you believe that he ingested marijuana and he was a ticking time bomb, and that he just so happened to die after being in a struggle with police, after being put on his stomach, after being handcuffed behind his back. It's like saying if Herman was hit by a truck, that the cause of death is THC. Except Dr. Smock's not a truck driver. Dr. Smock's a police officer. So it can't be the police's fault, because he's done that, because police do that. And if it's the police officer's fault, then that's a problem. Dr. Steinberg's a cardiologist. His business is the human heart. He looked at that heart and he said, yeah, it's big, but not abnormally large for a man of Herman's size. When you get bigger, your heart gets bigger. Yeah, Herman had some issues with his heart, but he's not going to drop dead. Those things are fixable. You know what did cause Herman to drop dead? The fact that he was in an agitated state. He needed to breathe. He needed to breathe in. He needed to breathe out. And every doctor, except Kroll, agrees that when you're on your stomach, it's harder to breathe. And when it's harder to breathe, acid builds up in your body. And when acid builds up in your body, it can result in a sudden cardiac arrest, which is precisely what happened. This isn't a civil courtroom. We're not alleging a mistake. We're not alleging a failure to act. There's something more that was going on that body cam, because they kept him down. Catatonic state? No. That's not what Officer Amott thought was happening. Herman must have been doing something that we didn't see, because I don't want him to get back up again. I was done with it. I'd had enough of Herman. I asked him 45 times to put clothes on, and 45 times he wouldn't do it. And now I've had enough. So I'm going to keep him on the ground until I can make Herman someone else's problem. And when I can pass him off, I'm going to go to the next run. That's what happened in this case. They put Herman on his chest, on his stomach, and held him there using force until he died. You can watch the video. You can decide when you think his heart may have stopped. That's what the experts did. It's not clear. And as we've heard, the video doesn't tell everything. It doesn't tell the whole story. There was something else going on that these officers felt, that these defendants felt, for why they had to keep him on the ground. It's the medic's fault. It's his parents' fault. It's Herman's fault. And now they're throwing the rookie under the bus. The guy who was most closely in time connected to the academy, who was most recently trained about what to do when someone is in a mental health crisis, someone who needs help. We need to roll him over. They chose not to do that. They chose to keep him on his chest. They chose to put pressure into his back. They chose to hold him in place until he died. They chose to do nothing to help Herman. That is the criminal conduct. That is not objectively reasonable. You just heard 60 minutes of rationalizing behavior. They were obligated to arrest him, obligated to handcuff him because it was an immediate detention, and that's what their training says. Well, guess what else their training says? Don't leave him in the prone position. Don't put him in the prone position. Don't keep him in the prone position. But they don't have to follow those because they didn't do those. If they did it, great, we had to. If they didn't do it and we were supposed to, that's okay. We get to decide. Which is why you have someone like Officer Young tell you that it's objectively reasonable to do anything. Hold him down, reasonable. Keep him down, reasonable. Roll him over, reasonable. That's not an analysis. That's rationalizing behavior. He watched the video and found an excuse for why everything was fine. But it's not fine. They committed a crime. Herman needed help. Herman didn't need to be held down until he died, which is exactly what happened to him. Millions of people use marijuana daily. Dr. Smock would have you believe that one of those millions of users was Herman, and that of the millions of people who use marijuana daily, he's one of the very, very minuscule people who died. That's not reasonable. And while prone restraint deaths are unusual, there aren't millions of people every day, like Herman, put into the prone restraint position and held down. And that's because officers all across the country are trained not to do that. If they were trained to do what these officers did, we would see a lot more deaths like Herman's. That's why it's an apples and oranges comparison when you're talking about rare occurrences. Marijuana deaths are rare, but millions of people use it a day. Prone restraint deaths are rare because every major law enforcement organization across the country, as Dr. Adams told us, trains their officers not to do exactly this thing. That's why these deaths are rare, because nationwide, don't do it. Indianapolis, don't do it. These officers don't do it, but they did it, and that's why we're here. We know that Herman may have had an adverse reaction to marijuana in the past, and it's actually a perfect example of why we know marijuana didn't kill him here. He was agitated. He used marijuana. He had to go to the hospital. He needed help. The difference between those two circumstances is when the police in Florida encountered Herman, they didn't handcuff him. They didn't put him on his stomach. They didn't hold him on his stomach. They didn't keep him in the prone position until he died. They took him to the hospital. And what happened? Herman walked out. He went home. He lived for another couple of years. But in this case, basically the exact same set of circumstances, the big difference is what the police did. They held him down. They stopped him from getting up. And he died. He never even got to the hospital for the help that he needed. That's the difference in this case. What you need to focus on is what these officers did, what their training required them to do, what a reasonable officer would do when confronted with this set of circumstances. They told you Herman was a threat. There must have been something he did to make them think that, or else they just got up and lied to you. Herman was doing something that made them think he was ready to get back up. You may not see it on the video, you may not hear it on the video, we weren't there, but they were holding him down for a reason.
3 minutes.
Thank you, Judge. They were holding him down, and holding him down, and holding him down. And they didn't have to use a lot of force. There were two of them. Herman's not going anywhere. He was too big to pop up on his own. They must have thought he was. He must have done something. Because otherwise, why act in total contrary to their training? They held him down until he died. It's not reasonable. It's not appropriate. It's not lawful. They're responsible for what happened, Nobody else. Not the medics, not Herman, not his family. It's these two defendants. Because if they had done what they were supposed to do, Herman would be here, and we wouldn't. And that's why I want you to find us guilty. Thank you.
Members of the jury, the bailiff will be handing you copies of your final instructions, which I will read to you. Once everyone has a copy. They're given to you to read along with as I read them. Members of the jury, when you were sworn to try this case, you became part of this court and entrusted with the enforcement of the law and the administration of justice. This court in its preliminary instructions has heretofore instructed you as to the issues for trial, the burden of proof, the credibility of witnesses, and the manner of weighing the testimony received, which preliminary instructions should be considered by you, along with the following final instructions, in arriving at your verdict in this case. As to these instructions on the law, read to you by the court, and which you will be allowed to take to the jury room with you, it is impractical to embody all applicable law in any one instruction. So in considering any one instruction, you should construe it in connection with, and in light of, every other instruction given. Number 2, direct evidence means evidence that directly proves a fact, and that, if true, conclusively establishes that fact. Circumstantial evidence means evidence that proves a fact, from which you may conclude the existence of another fact. It is not necessary that facts be proved by direct evidence. Both direct evidence and circumstantial evidence are acceptable as means of proof. A conviction may be based solely on circumstantial evidence. Where proof of guilt is by circumstantial evidence only, it must be so conclusive and point so convincingly to the guilt of the accused that the evidence excludes every reasonable theory of innocence. Number 3, statements made by the attorneys are not evidence. Number 4, you should judge the testimony of the defendant as you would the testimony of any other witness. Number 5, your verdict should be based on the law and the facts as you find them. It should not be based on sympathy or bias. Number 6, these instructions do not contain any information concerning a possible sentence. The court alone is responsible for sentencing if there is a conviction. 7, when the parties agree to certain facts, you should accept those facts as true. 8, under the Constitution of Indiana, you have the right to determine both the law and the facts. The court's instructions are your best source in determining the law. Number 9, in this case, the state of Indiana has charged the defendant Stephen Sanchez with count 1, involuntary manslaughter, a level 5 felony. Count 2, reckless homicide, a level 5 felony. Count 3, battery resulting in serious bodily injury, a level 5 felony. Count 4, battery resulting in moderate bodily injury, a level 6 felony. Count 5, battery, a class B misdemeanor. The charges read as follows. Count 1, Stephen Sanchez, on or about April 25, 2022, did kill another human being, to wit Herman Whitfield III, while committing or attempting to commit a battery. That is to knowingly touch Herman Whitfield III on the head, neck, and or torso in a rude, insolent, or angry manner. Count 2. Stephen Sanchez, on or about April 25, 2022, did recklessly kill another human being, to wit Herman Whitfield III. Count 3. Stephen Sanchez, on or about April 25, 2022, did knowingly touch another person, to wit Herman Whitfield III, on the head, neck, and or torso, in a rude, insolent, or angry manner, and said touching resulted in serious bodily injury, that is unconsciousness. Count 4. Stephen Sanchez, on or about April 25th, 2022, did knowingly touch another person, to wit, Herman Whitfield III, on the head, neck, and or torso in a rude, insolent, or angry manner, and said touching resulting in moderate bodily injury. Count 5. Stephen Sanchez, on or about April 25th, 2022, did knowingly touch another person, to wit, Herman Whitfield III, on the head, neck, and or torso in a rude, insolent, or angry manner. Number 10. In this case, the state of Indiana has charged the defendant Adam Ahmad with Count 1, involuntary manslaughter, a level 5 felony. Count 2, reckless homicide, a level 5 felony. Count 3, battery resulting in serious bodily injury, a level 5 felony. Count 4, battery resulting in moderate bodily injury, a level 6 felony. Count 5, battery, a Class B misdemeanor. The charges read as follows. Count 1, Adam Ahmad, on or about April 25th, 2022, did kill another human being, to wit, Herman Whitfield III, while committing or attempting to commit a battery, that is, knowingly touch Herman Whitfield III on the head, neck, and or torso in a rude, insolent, or angry manner. Count 2, Adam Ahmad, on or about April 25th, 2022, did recklessly kill another human being, to wit, Herman Whitfield III. Count 3, Adam Ahmad, on or about April 25th, 2022, did knowingly touch another person, to wit, Herman Whitfield III, on the head, neck, and or torso in a rude, insolent, or angry manner, and said touching resulted in serious bodily injury, that is, unconsciousness. Count 4, Adam Ahmad, on or about April 25th, 2022, did knowingly touch another person, to wit, Herman Whitfield III, on the head, neck, and or torso in a rude, insolent, or angry manner, resulting in moderate bodily injury. Count 5, Adam Ahmad, on or about April 25th, 2022, did knowingly touch another person, to wit, Herman Whitfield III, on the head, neck, and or torso in a rude, insolent, or angry manner. Number 11. A person's conduct is legally responsible for causing a death if 1. The death would have not occurred without the conduct, and 2. The death was a natural, probable, and foreseeable result of the conduct. This is called a proximate cause. Number 12. A person engages in conduct knowingly if, when he engages in the conduct, he is aware of a high probability that he is doing so. 13. You have heard evidence about whether officers Adam Ahmad and Stephen Sanchez's conduct comply with the rules and regulations of the Indianapolis Metropolitan Police Department. You have been provided this evidence to help evaluate how officers are trained. However, lack of compliance with rules or regulations does not establish that a crime was committed, nor does compliance with rules and regulations necessarily establish that a crime was not committed. In other words, the issue before you is whether officers Adam Ahmad and Stephen Sanchez committed the crimes charged, not whether their conduct did or did not comply with departmental rules or regulations. 14. The term legal authority is defined by law as follows. A person is justified in engaging in conduct otherwise prohibited if he has legal authority to do so. The state has the burden of disproving this defense beyond a reasonable doubt. A police officer is justified in engaging in conduct otherwise prohibited if he has a legal authority to do so. Specifically, a police officer has the right both under the federal and state law to use force to seize, arrest, or otherwise detain a person when it is reasonably necessary to do so under the totality of the circumstances. Thus, if the defendant complied with the requirements of the use of force statutes, he therefore acted with legal authority, and the actions of the defendant would not constitute a violation of the criminal battery statute. 15. A person engages in conduct recklessly if he engages in the conduct in plain, conscious, and unjustifiable disregard of the harm that might result, and the disregard involves a substantial deviation from acceptable standards of conduct. To convict a defendant of reckless homicide, the state must prove the defendant acted recklessly and not merely negligently. That standard is not met if the incident arose out of inadvertence, lack of attention, forgetfulness, or thoughtfulness of the defendant, or from an error of judgment on his part. 16. It is an issue whether the defendant mistakenly committed the acts charged. It is a defense that the defendant was reasonably mistaken about a matter of fact if the mistake prevented the defendant from knowingly or recklessly committing the acts charged. The state has the burden of proving beyond a reasonable doubt that the defendant was not reasonably mistaken. 17. The objective reasonableness of a particular use of force, if any, must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Number 18. The burden is upon the state to prove beyond a reasonable doubt that the defendant is guilty of the crime charged. It is a strict and heavy burden. The evidence must overcome any reasonable doubt concerning the defendant's guilt, but it does not mean that a defendant's guilt must be proved beyond all possible doubt. A reasonable doubt is a fair, actual, and logical doubt based upon reason and common sense. A reasonable doubt may arise either from the evidence or from a lack of evidence. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you have weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crime charged by evidence that firmly convinces each of you and leaves no reasonable doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find that there is a reasonable doubt the defendant is guilty of the crime, you must give the defendant the benefit of that doubt and find the defendant not guilty of the crime under consideration. 19. You should give separate consideration to each defendant. Each defendant is entitled to have his case decided on the evidence and the law that applies to him. If any evidence is limited to one defendant, you must not consider it in deciding the case of any other defendant. Can the parties approach real quick?
Number 20 was going to come out, and we were going to stick with the one
Yes,
earlier.
which I've already read.
Yeah, okay. I think we skip over 20 and go to 21.
Okay, thank you. Good decision, Mike. Sorry. My apologies, folks. Instruction we debated last night was in my packet. Just wanted to make sure you didn't have it. To return a verdict, each of you must agree to it. Each of you must decide the case for yourself, but only after considering the evidence with other jurors. It is your duty to consult with each other. You should try to agree on a verdict if you can do so without compromising your individual judgment. Do not hesitate to re-examine your own views and change your mind if you believe you are wrong. But do not give up your honest belief just because the other jurors may disagree or just to end the deliberations. After the verdict is read in court, you may be asked individually whether you agree with it. When you begin, select one of your members as foreperson to manage the deliberations. No one will be allowed to hear your discussions, and no recording will be made of what you say. The bailiff is available to assist you with personal needs, but cannot answer questions about the case. Any questions for the court must be in writing and given to the bailiff. The court often is not allowed to answer your questions except by rereading all the jury instructions. Because the court has given you those instructions, you may be able to answer your questions by reviewing them. If there is a break in deliberations, do not talk about this case amongst yourselves or with anyone else. The court is submitting to you forms of possible verdicts you may return. The foreperson should sign and date the verdicts to which you all agree. Do not sign any verdict form for which there is not unanimous agreement. Sign only one verdict form for each count. The foreperson must return all verdict forms, signed or unsigned. When you have agreed upon a verdict, inform the bailiff. When the parties are present, you'll be brought back to court for the verdict to be read. After you return with the verdict, you are under no obligation to discuss it with anyone. Alternate jurors, which are 13, 14, and 15. I'm looking at you three back there. You have been selected as the alternate jurors. Your duties are the same as those of the regular jurors, except you must not participate in the deliberations or voting of the jury unless I direct you to do so. The foreperson shall prevent alternate jurors from deliberating or voting with the jury. The foreperson shall promptly report any violation of this instruction to me. The jury having been so instructed, Ms. Wood and Ms. McCullough, please raise your right hand. As bailiff of the court, I now place this jury in your charge. You solemnly swear or affirm under the penalties of perjury to keep the jury in this case together in the jury room in this courthouse, to furnish them with food as directed by this court, and to permit no person to speak or communicate with them, to speak or communicate with them yourselves only by order of this court, or to ask them whether they have agreed upon a verdict, and to return them into court when so agreed or when so ordered by this court.
I do.
And do you further solemnly swear or affirm under the penalties for perjury that you will not communicate with any person the stated deliberations of the jury?
I do.
Bailiffs, the jury is in your charge. Take them to the deliberation room.
All rise.
We've already decided. Be seated, folks. Anything we need to address as the jury begins their deliberations? Okay.
Also with the others.
Was there nothing?
I'll recess it.
Okay. It's been a long week. As judge here, I only see certain things. Some of this I see for the first time when it's played into evidence. You all have lived with this case for quite some time. I want to thank everyone for their advocacy and their civility, as always. And at this point, we're just waiting on the jury. Okay. This court will stand in recess.
Thanks, Judge.
Make sure the bailiff has your numbers, counsels.
Rather sure.